We are here to do the business law presentation under the case study negligence of business and contract laws. So the introduction: business law or commercial law is eventually the framework of law which is involved in governing the commerce and trade. Sometimes commercial law is eventually considered as the branch of the law possessing with civil needs and also involved in dealing with both the challenges of public and private. So we have a couple of issues at the moment. We have in the year 1999, June, Volvo and plaintiff have able to enter within negotiation that plaintiff want to become an effective dealer of Volvo Car Company of Australia. It has been recognized from the case study that for the request of Volvo, plaintiff has been engaged in designing and also preparing plans for their new showrooms. So my fellow team member will go through rules and analysis. Thank you.
Hi, I am here for the rules. The rules is the content and scope of contracts, remedies for violating and breaching my contractual law, evidence in the application of my contracts, termination and performance of the contracts. So we have analyzed that moreover it has been mentioned in the contract law that if the court of law able to find out that in a contract if anyone has done any violation that the person will get punishment from the court of law. In the case study of plaintiff, it can be said that Volvo company either have to give compensation or need to act according to the 5 years contract.
Hello, I'll do the part of the conclusion of the issue. After recognizing the issue that has been raised between the plaintiff and the Volvo Car Company, it has been suggested that the person can move to the court of the law by mentioning the Volvo has been involved in breaching the contract law. Now, next to the part of the issue, in case of the Wilson and the Honey, it has been informed that the plaintiff is the resident of Tasmania. The plaintiff has been subjected for sexual arrest by the defendant of the case. As for the issue of the part, it has been divided into 8 part of that. All right, let's do the next part.
So the part that I'm going to tell you about is rules, and with the rules, the subsection 1 cannot be applied as the claim for the harms related to the failure for providing professional health and service. The plaintiff cannot claim the damage because the risk is associated with the work done by a person for another person. So with this one here, we have got the 7 stages of legislative process. With the first one, it's reading. With the second one is committee stage. With the third one is timetabling. And with the fourth, it's second reading. And with fifth, it's third reading. And with the sixth part, it's conference committee. And in the last, the presidential action is required. Continued furthermore, this section has described the meaning of the risk, which is obvious. Under this section, it has been clearly stated that obvious risk of the person means the individual who may suffer the harm, which is a risk that in the circumstances. The risk may include, which is mainly patent for of the common knowledge. So my fellow member will tell you about the conclusion now. Thank you.
Hi, my name is Tashi. I'm gonna do the conclusion. Concluding on the point, it can be started from the above analysis that tort of negligence can be applied by the plaintiff of the case. The given case example can be helpful for this purpose to understand the limitations and liabilities of the act. It can also be concluded that the civil law of tort is essential to understand for analyzing the tort of negligence. And on the other hand, the contract law is important for the understanding the breach of contract.